I've heard a lot of people say, well, why don't we just wait for the criminal case to finish? Law enforcement officers are much more capable. They are trained. They are the people that should be conducting these investigations. So we'll just let them do it. That was a big argument against Title IX cases, where it was that universities shouldn't be in the business of investigating rapes. Well, that argument could be applied to any kind of misconduct because most misconduct is also a crime. You have a right to investigate misconduct that happens in your organization. You have a responsibility to do it correctly, to pursue and receive the training so that you are doing it professionally. There's no excuse for not doing it correctly, but you still have a right to do it. And if you're thinking, well, let's just wait for the criminal process, that can take years. So are you prepared to have your respondent continue working for you, given the alleged behavior, for years before you make a decision? Because that's how long it's going to be before the case has gone through the court system and you can get access to the reports. Business moves at a much faster pace than government. So I would venture to guess that you can't wait for a criminal case to be done. Maybe there are instances where it makes sense. We had a Title IX case where it did make sense, and the student actually agreed with it, and that was important. The student agreed and actually stepped away from school to focus on the criminal case, to focus on his criminal defense. And so it worked for the university because the student wasn't actually attending classes. He was focusing on the criminal case. Once that was done, we opened our administrative investigation. And at that point, we did have access to some of the information from the criminal case, which helped. If in this instance, it actually had a big impact on the outcome. But that only worked because the student agreed to take time off from school during that time period. Usually it doesn't work. That was an exception. So you can talk about that in your policy if you want to. I think it's more of a practice thing. It's not necessarily a policy-driven decision, but it can be. If it's something you believe you will do on a regular basis or that you are going to seriously consider in a lot of cases, then you probably will want to include it in your policy. If it's going to be the very rare instance, it's more of a practice thing, and all involved should be in agreement, and that should be documented. That was also very important that it was documented, the conversations between the university and the student. If you have this good relationship with law enforcement, that'll help you know when you can proceed. You don't want to screw up their case. You don't want your administrative case to screw up a criminal case. So someone gets away with a crime, doesn't go to jail because of something you did. If you have a good relationship, open line of communication, you can prevent that. You can have that conversation. Hey, I understand you're working your administrative case right now. We actually have an upcoming operation this week. We've got some stuff planned. So could you hold off until next week doing anything? Sure, roger that. That one little phone call has a very large impact on the case. But that phone call is not going to happen if you don't have a relationship. Instead, there will be no phone call. You won't know. You'll move ahead, and then everyone will be angry that you screwed up their operation, and you're sitting there going, well, I had no idea what was happening. How can I screw something up that I don't even know is happening? We talked a little bit about providing your statements and file, and you may choose to do that. But just remember, your entire case file may just be subpoenaed. Instead of asking for it, they may just straight subpoena your entire file. That's another reason to make sure that your file is thorough, that you have a good investigative plan, you've documented everything that you've done, and that they can look at your file and see that you know what you're doing. You are trained, you have experience, and you're doing a good job. You might have things that they can't use. You're not bound by Miranda. You don't have to read or respond to their rights under the Constitution. You may have something you have to inform them of with their contract or bargaining agreement or something. But as far as their Miranda rights, you don't have that requirement. You don't have other constitutional rights that you had to abide by. But the more you ensure there's equity in your cases, the more that you ensure that you are giving them what would be considered due process in the courts, the more professional your case file looks, the more professional your investigation looks, the more it looks like you know what you're doing. That case file is going to be looked at and judged by the detectives and law enforcement, the prosecutors, and potentially a jury and a judge. And all of those people are going to be judging how well you did, what kind of investigator you are. So you're no longer just the little investigator from this company. You are now being judged as a professional investigator by professionals, other professionals in the field. So if your case file is solid and thorough, that will engender trust that you know what you're doing, which will promote your relationship, promote future cooperation. A detective is much more likely to call and cooperate with someone that they trust in and know when they know what they're talking about. That was one advantage for me as I got to know law enforcement in the area, is they recognized that I could speak their language and I knew what they were talking about. I was experienced. I knew what I was doing. And your work product is how you build that. That's what they see.